ராசா ரைட் ஷேரிங் கம்பெனி ARASA.ca என்ற இணையதளத்துக்கு சென்று ராசா டிரைவர்ஸ் ஆப்பினை டவுன்லோட் செய்து டிரைவர்ஸாக வேலை வாய்ப்பை பெறுங்கள். மாதாந்தம் $4000 வரை சம்பாதியுங்கள். வணிக நிறுவனங்கள் ராசா இணையதளத்தின் மூலம் மளிகை பொருட்கள் மற்றும் உணவுப் பொருட்களை விற்பதோடு வாடிக்கையாளர்களுக்கு டெலிவரி செய்யலாம். தமிழில் தகவல்களை அறியாளையுங்கள். GTA பற்றி 40 ஆண்டுகள் அறிந்து கொண்டவரும் வீடு விற்பனை துறை ஊடாக மக்களால் அறியப்பட்டவருமான சிவா பிள்ளை. 416-854-0005. Taxi broker licensed by City of Toronto.
Recording in
the real estate
progress.
cycle is changing. We are getting the chance for each and everyone to get involved, and make money for this industry. If the industry go the same way, and some real estate agents are doing their certain kind of marketing, that particular top 2% of officers, 3% of the agents only make money. The real estate market should change. Then supposed to move from the seller's market to buyer's market, pre-construction to regular resale properties. In that case, only every one of us, we can get the fair share in our hand. The market changes. I am looking the real estate since 95, guys. The market changes, different group of agents works. What is the difference now? Because we came to this industry to make millions. In that case, what you had to do, you had to take advantage of the market. What kind of advantage you going to do? Now the market is changing from seller's market to balanced market. I'm not saying the buyer's market completely. The market is changing to the balanced market. That's mean there is a bargain is there for the buyers. The buyers, how many buyers waited to buy? Not only the buyers waited to buy, how many people wanted to invest in the real estate industry? The good news for us in the real estate industry, the stock market crash big time. The last 1 week, 2 weeks, even though you are an investor for the stock investor or not, you may hear the news. How many percentage of stock market lost their values? In that case, real estate market also, the paper money little bit moving around, but at the same time, real estate market still steady market. You can tell your buyers, you can tell your investors and the buyers the right time to start to look around the properties, and they started to buy. They started to do the bargain. No one know the bottom part. Where is the bottom part, or no one know where is the high part. But at the same time, that compared to the January, February month, right now, the month of June is a very good month. The end of the month, school going to be holidays. There are parents wanted to move the kids from one place to one school to other school. Many people started to look before they go vacation after July 15th. This is the right time, guys. Work with the buyers. This is the right time to start to get involved. Nobody going to knock your door and give you the deals. You had to go out. You had to go out and you had to do your marketing. Okay. Again, the $1 million question: are you satisfied for your product? Are you satisfied the income you are making it? Last year you made $1 million, doesn't mean you're going to make this year $1 million. Our clock start every year January 1st from zero to go on until December. Okay, do your marketing, change your marketing style different. Target the buyers from all over the angles. All over the angles, look at the buyers. First, newcomers to Canada. They're coming. There is no stop. We can see downtown Toronto condos is going back again. Why? The people are coming from different countries, and the people are moving from one area to other area. The market is moving. So plus the investors who was waiting to buy the properties. This is the right time for you guys to do your marketing for the investors. Do the investors marketing. And if you see the bigger properties, introduce investors to invest the properties in the multi-residence or any other properties. Guys, work hard. This is the time. If you see any changes in the market, take advantage of the market. In my side, real estate, whatever happening in the market, real estate agent, we are the game we are playing. Win and win game. We don't have any losing game. Every market changes, we win. Because we are not an investors. We are only salespeople. What product we going to sell? Who is the clientele we going to sell? That's the only one we need. The product we going to sell is changing right now. And the clients tell you going to take whoever want to buy more buyers rather than the selling side. Okay. Target those one. And every day, please. This is, I repeat every day, same thing sometimes. Allocate yourself at least 15 minutes per week. 15 minutes per week and think about what is the direction you are going. Am I doing the right path? But what is my goal? What is my goal? Am I doing the right path? Am I get distracted? Or am I postponing my the marketing? Am I postponing anything in my life? In that case, pull back yourself. Okay, don't worry about the market. Interest rate change, we can't control it. The price go up and down, we cannot control it. What we can control, our work, our target clients. Our target clients is the one we can control it. The government of Canada changing the interest rate. Why we want to sit down and worry about? We will talk about the interest rate hours and hours. What gain we going to get? Nothing. We are salespeople. We had to learn to sell any market condition. Any market condition, we had to learn to sell. Look at the MLS. We have the MLS. Go to the MLS and see how many transactions are happening. If yesterday one of the clients bought a property for 1.6 million, but then they indirectly come and ask me for the advice. Can I wait or not wait? And they told me they sold the property in last February and they made 800,000 profit. And they're going to live there. My answer was them, are you going to live there? You bought it, already made $800,000 and you're going to wait they said the kids are growing up, they need the property now, right now, with the bigger basement, pool and so many other things. Even though market might change 50,000 or 75,000, maybe further at the end of the year, doesn't matter because it's a paper money. You want to buying and living there. We want to buy and live there. If somebody buyers want to buy and live there, you don't need to tell them to wait for the market. Do it now. Do it now is better. They're not going to lose anything. They already made 800,000. Then I told them, what are you going to do? You're going to wait for 1 year, 2 years and see, or else you want to start, your kids start to enjoy right now. They said they can start to enjoy right now. Then I said, firm up the deal. Firm up the deal and move on. Guys, honestly saying, when you work with the buyer, you have to understand from last year, January, February, and right now, at least 200,000 market change. That's the advantage. They had to take it right now rather than their dreaming market might go more further. If they buy and live there, investor side, yes, of course, they had to look at the money in and out. They had to look at the money for in and out, the profit and losses. They may need to look at it, but the buyer side, don't delay for the buyer side. I have few questions. I have few questions to discuss. What is going on? What is going on this? What is exactly going on for this week? The main thing to discuss: Toronto Real Estate Board complaint for the listing type. So far this week, we received 2 complaints from the Real Estate Board Arbitration Department. MLS site, Toronto Real Estate Board MLS arbitration site, they sent the listing. Our listing already sold, not active listing, sold for a few months ago. They said condo listed as under the freehold category. Condo listed under the freehold, the prosperity pathway. Detached condo house is listed under the freehold area. But there are all this time that listing was there for last 5 times, and there are so many other people also that still listing it. But we got the letter, and we sent the letter back to the Toronto Real Estate Board and asked the apology and all this one. Yesterday we received other one, and 3 months ago we received one of the Mississauga property is a townhouse property. The salesperson was changing it, and our salesperson is a senior salesperson, is a top producer, producing salesperson, and he changed it a few times. The house is a townhouse and link detached. Downtown it is because the house is located. Only the garages is the one touching each other. That's been we have an argument. His argument is a link detached. Previously was listed and originally was listed. Town it's a real townhouse. It was listed for he was changing it. All right, we explained to them and clear explanation, and the seller asked to list and everything. Guys, yesterday we got the letter. Yesterday evening 3 o'clock I got the letter. There are 2 salespeople together. They put the listing. Each salesperson $500 fine and $500 administration charges. That's mean each salesperson $1,000 and the office charges $1,000. In total, Toronto Real Estate Boards charging that particular listing, the two salespeople and the office, $3,000. I'm not talking the dollar value, but still is a dollar value. I don't think office even make that listing $200-300. I don't think so. But we are going to end up paying now $1,000 for the office, and other salespeople are going to put another $2,000. And another two more cases we are on pending. What does this means? I know as a listing agent or as a salesperson, you want to list the property for the sale, and you want to list it under the freehold. Everybody doing it. In that case, next time what we're going to do, we're going to ask you to sign letter from the seller and the salesperson office side. There are, if you other than the land registry category, if you want to list the property in any other category, you are taking the responsibilities for the fine and penalty for your own as well as the office. I repeat again, each and every listing from Monday and onwards, we're going to pull the land registry, how the land registry is showing. That's what the real estate board has to do. If the land registry showing freehold, is freehold. If the land registry showing is the condominium category, you have to list under the condominium category. If you want to list under the freehold category, we are going to ask the form to sign. The salesperson is responsible for the penalties from now on onwards, for the office penalty as well as your own penalty. Otherwise we will lose money on this one. Very careful when you list. Every salesperson, okay, every seller wanted to say this is listed under the freehold, but we have already received the letters, experience all this time, right? Like this kind of, we are driving the street. The person in front of me is driving faster than me, but police catch me and give the ticket. Nothing I can do. I can say the other person is driving faster than me. Similar situation we are right now. From now on onwards, we're going to have a category of the listing, and where are we listing it? We have to, if you want to do your own way, you have to get a signed letter to the office. You are responsible for the fine and penalty. It comes in the future. This is one thing, guys. Other one, the salesperson. I was looking his number to call him. I couldn't able to find it today, but I was talking to him yesterday. The salesperson called me, and the question he asked, his client already booked the condo apartment. He already paid 5%, and he doesn't have any other rest of the money close the transaction. The transaction might close the transaction within 2 to 3 months, and occupancy closing is completed, and he want to assign the transaction. And I asked him, extra question I asked him, he may be listening right now. Did you came to my training and see the assignment changes for the government? He said no. I said to him, if some sellers giving you the responsibility, you had to have a knowledge. I asked him to come to the Zoom meeting today. Okay, guys, this is an old story, but still, whoever doesn't know, the government changed the listing, the assignment side. Assignment is the assignment side since April 7. They passed the regulation from May 7th and onwards. Assignment, whatever the profit you are getting, whatever the profits the seller is getting, whatever the profit, if it is 100,000 profit, whatever the profit seller is getting, that's subject to HST. They had to pay the time of the assignment transaction. Before the close the time of the transaction, lawyer is supposed to collect the HST and pay to the Revenue Canada, Government of Canada, the HST money. And in case that the seller is a non-resident, that HST part is moving to the buyer side. The profit, the assigner, original buyer, assigner make, that's going to be subject to 100% profit, not 50% capital gain. Please careful and explain to your assigners, or explain to the buyer. Assignment season is almost come to the end, because of the profit margin is going to be less, as well as the taxes you had to pay more. And when it's come to the taxes, last 2 weeks, no, I can say within 1 month, I'm getting the letter. I am seeing the letters from my tax business. It's good to share with you guys. whoever sold the property since 2016-15, they are asking right now. They are getting the 2 letters I already seen. Within 2 weeks, they sold the properties in 16, 17, 18, and even the primary residence or investment properties. They are sending the letters and asked to list all the properties, and they are listing some whatever they found, and they ask me to disclose you what are the properties you sold and what are the categories. The questionnaires is a really big questionnaire. They are asking. That's the information I'm sharing with you guys. The property sold and not reported to CRA. Please educate yourself. If the seller come for the assignment, please educate yourself and come to the Zoom. Don't call me alone and say, can you briefly explain to me about the assignment? 650 people, so I cannot briefly explain for just one person in the phone. Come to the Zoom and ask. It's good for everybody. There are certain other questions. And the next one, we receive one commission dispute from other Remax office. The commission dispute means our office agent officially sold over $2 million worth of one commercial property, and that Remax complained the agent never make the appointment and never introduce the client to that particular property. That offer DocuSign not from that agent. That listing agent did everything, and they are using our office agent as a Pinami, or using our office agent as a cooperating broker to get the commission. And that particular Remax office asking, send me the letter with the proof, and they even send me the letter saying that one DocuSign, which email address is the DocuSign, and where is the person based on the IP address, which location the agent send the email to the clients based on the IP address, and that's commission dispute. We are talking about a commission over 75,000 right now.
It's not. Can hear you.
We are talking about the commission over 75,000. Even I checked the file. That office, that offer not made by our office. Anyway, what I'm trying to say, real estate is a serious industry. You cannot do whatever you think you can do. Then what will happen? You end up go to the courts. You end up go to the courts and stand there. If somebody want to use your name to take advantage of their commission, guys, at least nobody's Buddha, but at least be your head. At least make appointment and show the property. You can do the communication with in your phone, in your email, rather than somebody else do everything and sending the bill to the other company. For me, this is going to be other legal dispute. The salesperson go to the court. So I don't think Rico will handle this one. We will see. I will update you guys what's happening. If somebody want to take advantage of you, be careful. And the next one to share with you guys whatever happened this week. I'm sharing with you. This is a good knowledge, rather than a good knowledge for you guys. I'm sharing the information. Land surveying. One agent asked me his client want to survey 1 acre lot, and a city is ready to approve, but the city asking for the environmental report. Then he asked me for the environmental side, and we did 2 weeks ago. We did the environmental company came and explained you guys, and I send you the video to watch for the environmental side. But in his side, environmental phase 1, as I just, whoever wasn't there that particular meeting, I am reviewing your knowledge. Environmental phase 1 is a report. Environmental phase 1 is only a report. That report we're going to get the information from the federal bureaus. That's been like a credit bureau. We're going to get the information. If the environmental phase 1 shows clear, we don't need to do the environmental phase 2. But if the environmental phase 1 is not clear, we have to do the environmental phase 2. Phase 1 is only a report, getting the information and inquiring the owner, inquiring neighbors and those kind of those kind of things. There are no physical testing. That's phase one. The cost $3,000 to $5,000 for the environmental phase one report is only a report. Environmental phase two is a soil test as well as the underwater mineral, underwater pH testing. Those one, how much is cost based on the size of the land and based on the usage of the land. Based on that one, this can cost, but according to the big environmental company said, this can be anything from 20,000 to 40,000 or even much more because of the size of the land. And based on his question, is only for the severance because it's an empty land. But according to the salesperson, he said the owners found the 150 years ago. That means the report is there. They have a report until 100 years now. 150 years that land owned by one of the oil company, but there's no evidence the oil refining was there or oil site was there, but the land was owned by the oil company. Then I told him I suspicious they don't let you go with the environmental phase one and they may need to go environmental phase two in this situation. Just passing the message for you guys. If somebody wants to severance the land, they may need to get the environmental report. And the next one, canceling the deal. One of the salesperson called me at least 5-6 times for last 1 month. Then he said he sold the property and they bought the property and the property value going down. The buyer doesn't want to close the transaction. And finally, I told him, please understand, you have a purchase sale agreement. If you have a purchase sale agreement, you are committing to you have a contract, you have a valid contract under seal, you are buying the particular property. All this time market went up, guys. We already seen it. Market went up, we already seen it. 2017 after the crash, market went up so much, and 2000 real estate market last 20 years going up. Even last 2 years. Once you close a transaction, after you firm up the deal, before closing the transaction, agent coming and saying the house went up 200,000. You bought from the builder. Before you close the transaction, 400, 500,000 price went up. Same thing, price going down. The agent agent conversation with me at least 5-6 times. Price went down. In that case, how can I negotiate with the seller? As a broker of record, guys, please understand, educate yourself. You can talk to the seller, but there's no reason seller need to come down the price. You can't tell the lawyer to negotiate the price going down or appraisal value come down. Appraisal value come down. We don't have a condition for the appraisal condition in the purchase sale agreement. If we have a condition for the purchase sale agreement, the time of the closing the transaction, appraisal value come down, seller has to reduce the price. That's a different story. But no seller is going to sign those kind of agreements. In that case, please educate yourself. Don't think in your head you can argue to reduce the price. We are salespeople. Explain to the buyer. Don't mislead the buyer. Whatever the deposit you are giving, the deposit is a good faith money. Is it in the trust account? That 99.9% that they can sue for the deposit. The further damages depends on the seller. Seller can go for the further damage, and they can sue, and they had to go for another lawsuit to collect the money from their side. If somebody is a wealthy person having 2-3 properties under their name, they can simply go for a big lawsuit and registering the other property under other properties. Okay, they can, even though the person doesn't have any other properties, still they can go for the lawsuit, and they can put it in the name side, the collection under the name. There are so many ways to do it. Please understand, as a realtor, you lose the deposit. One of the deal of a salesperson, I believe is $60,000. He got 2-time extension. After that, he prepared the mutual release from our office asking the full refund to the purchaser. I told him, how can you ask the full refund to the purchaser? They're not going to at least negotiate half. He said the buyer need all the money back. But the reason I'm talking this story is whatever I'm hearing, whatever phone calls I hear from all 650 salespeople, be educate yourself. educate yourself. The deposit money, very fair chance you can get back. Deposit go to the sellers. They can sue for the deposit very easily. They can get the money. It's a good faith money with an offer. Rest of the lawsuit depending on the seller. And other information I like to share, guys. This is one of the tax part for the real estate side, very important side. I feel like as a realtor, you should have at least some knowledge about this one. All right, the tax clients came yesterday, and he sold one of the rental property. Okay, the scenario is this: he bought a property in 2001 for 225,000. Of course, early 2000, the property value was 200,000. Properties are very reasonable property. Look at the properties, double garage properties is in Brampton. It's a nice property. They bought it for 225,000, and they lived that particular property. The time he buy the property, so the time he bought the property, husband name, wife name, plus they don't have some reason, the mortgage issue, maybe the credit issue, whatever the reason, income issue. The bank asked for the co-signer. Then the father-in-law was co-signed the particular property. Okay, they happily lived the property until 2016. 2016, he bought another property. The time he bought another property, he took the father-in-law names out from the property in 2016. The time, I can blame the lawyers too. The time 2016, the property moving from the permanent residence to as a rental property. The time they take the name out from the father-in-law name out, that intelligent lawyer put only $500 for the house value. Again, I repeat, he bought the property for 2001, 225,000. 3 people's name, husband, wife, and the father-in-law name. They lived there, the property for 15 years as a permanent resident. In 2016, the property value at least 800,000, 200,000, 800,000. It's a tax-free because of the primary resident property. Okay, what they did in 2016, they removed the father-in-law name out. That time, they don't want to pay for the land transfer tax. They want to reduce the land transfer tax. They show the property value in 2016 under the land registry. The only value they put $500 and put only $50 maybe land transfer tax, because they wanted to save the land transfer tax. Some lawyers are doing that low value and changing it. The affection right now, he already sold a property. He sold it for 950,000. He sold the property for 950,000 last November. He come and do the tax return. Then I look at the land registry. The real calculation supposed to go 2016 value, and the value increased right now. That's mean 216 value maybe 800,000, and the value right now 950. He has to pay for the capital gain only 150,000. But their mistake, they already committed to the land registry. The property value that time only $500. Then the property value moving from the primary residence to the rental property only $500. Now what they gonna do? $950,000, complete $950,000 is going to be under the capital gain side. He has to, that's mean $425,000 gain, multiply by 4. 160,000, 170,000, he has to pay for the taxes. Why? He saved the land transfer tax for $5,000. Whose mistake? His mistake, as well as the lawyer's the lack of knowledge. Saying that one, I can change it to $2, I can change it to $500, whatever it is. Please, if somebody asks you the advice, tell them to check with the accountants before they do the saving the land transfer tax for these kind of situations, guys. That's it. That's an experience I'm sharing with you for whatever I get at this week. If you have any question, please come and stop me and ask me. I'm going to go through with the, as I said, for the conditions. I'm going to go through the conditions. Again, I'm going to go through with the basic form number 100 for purchase sale agreement for the freehold. The freehold property, again, guys, please understand. Once you are signing the purchase sale agreement, because some buyers doesn't want to close and they want to walk away. If you are signing the purchase sale agreement, you are signing under seal. You are signing under seal, as well as you are giving the deposit as a good faith money as a deposit. In that case, it's a valid contract you are making it. After this is signed, accepted, after you waive the condition and everything, we have a valid contract. If we are not closing the transaction, we have the rights to go to the courts based on the contract. They can sue you for any amount depend on the situation. Second thing, understand again, purchase sale agreement signed by who? Buyer and the seller, real estate agents. We are only witnessing the application. I know this buyer, this is his handwriting, or else I'm working for this company. I need the commission. I'm listing this particular house. I'm the listing agent. Based on the listing agreement, I'm getting the commission and money. Real estate agent and the brokers, we are looking for only the money as well as guiding the peoples. But the real contract, who? Buyers and sellers. In this case, the real estate salespeople carefully advise the clients what they can do and what they cannot do based on the lawyer's advice. All right. Whenever you have a free time, please, this is a real estate business. Take the purchase sale agreement and read the standard clauses. Standard clauses there. The closed freehold property first clause number 1 in the standard form, irrevocability time, closing date, the notice. Number 3 is a notice. Number 4, chattels. Number 5, fixtures, and number 6, rental items. What are the items? Are rental item. Number 7, HST. Careful for the HST from now on onwards for the assignment deals. Assignment deals are subject to HST. Look at the HST side. HSTs and number 8, title search. Title search is very important. Every deal lawyer is supposed to get before the title search. If some good lawyers, downtown lawyers, the lawyer follow by the book. If you're sending the deal after the title search date, they don't take it. They don't take. Now I am hearing last minute the mortgage brokers changing the deal to other lawyer. Any lawsuit come, that lawyer also will be in trouble. Any lawsuit come, the last minute mortgage broker change the deal to one lawyer to other lawyer. Any lawsuit, buyer or seller go to the lawsuit, that's an issue again. Lawyer supposed to get the paperwork before the title search date. And future use, what are the use? We are buying the property as a single family resident. You cannot tell the clients do the basement and rent out the basement. That's under the municipality side. Okay. Number 10 is a title. Number 11 is a closing arrangement. Number 12, document and discharge. Number 3, inspection. Number 4, insurance. Number 15, planning act. Document preparation, residency adjustment. Please read, guys. Please read, because you are signing every single day. What is in the offer? What is in the standard form? At least take a time and read 15 minutes and know what exactly is there. Number 17, residency. 18, adjustment, property assessment, time limits, tenders, family law act, divorce, separations, family law act, UV clause. UV means urea formulated clause. That's all bungalows is the one. New properties, we don't need to worry too much. Number 4, legal, accounting, and environmental advice, consumer reports, the agreement in writing, electronic signatures, time and dates. These are up to first 4 pages as the standard pages. Other than the auctions and other than the power sale properties, there's nobody change those one. There's a standard clauses are there. Read and understand. If you are meeting the educated buyer, he will ask you to read and explain to you. This happened one of the salesperson in our office. He sold the property to one of the Bay Street lawyer. That agent said, the deal I did very, very easily, but at the same time that the lawyer, the clients are both are lawyers, I believe. They asked to read for each and every clause. Luckily, that agent was dealing it. He knows the clauses, and he explained the clauses. That lawyer was reading each and every standard clauses and asked for the explanation. Guys, you may get into the same situation too. Don't even sign only for the wherever you're supposed to sign. Please read and understand what exactly the purchase sale agreement is there. In that case, you will also get some idea what kind of paper we are signing, what kind of contract we are signing it, any legal issues come. All right. And we are going to the schedule. This is a regular, I'm starting with, we have a 1 hour until 11 o'clock. I'm starting with the freehold offer. Freehold offer, everybody you deal with the freehold offers. Freehold offers, but I'll go through the basic freehold offers. The new agents who are hearing it, they can listen, or else the senior agents, you can fresh your mind. Okay, first clause is the buyer agreed to pay the balance of purchase price. That's an important clause than anything else. If the buyer not agreed to pay the balance of purchase price, you are buying the property only with only the deposit. Even though you mark the property value is 10 million, $1 million property, if you don't have that clause, the buyer agreed to pay the balance of purchase price, there is no clause saying you're going to pay extra money for the closing the transaction. You can ask, I'll pay you 10 years later, because there is no, the clause is not there. That's an important clause, very important clause. That's the reason we put as a first clause. The second clause, the offer is conditional upon buyer arranging the satisfactory financing within 5 days. Guys, satisfactory financing clause. I can talk about this clause 1 hour if I want it. Satisfactory to who? Satisfactory for what? But at the same time, this is a standard American clause. We are using it for Toronto Real Estate Board. We are using it for years and years. Nobody question too much. But some real estate board, they don't allow this clause. But satisfactory for what? They may need what kind of down payment you're going to put, what is the rate of interest, or below what is the rate of interest you're looking for, those kind of more details, but doesn't matter. But this is the one we are using it. In that case, if the financing condition is 5 days, it's a 5 days. If you are going without financing condition, even we are sometimes the buyers are walking away. They can blame you, but what do you have to do? Put the clauses, put the financing clause in the offer, and cross it out, and ask the buyer to initial it and inform them there's a financing clause. You are voluntarily deleting the clause, and get the form 127 to sign. You understand and agree to canceling the clauses. You save your side. In the end, in case the deal doesn't close, in the end, you don't get in trouble. Okay, the financing clause. Second thing, the inspection clause. The offer is conditional upon inspection of the subject property by a certified home inspector, not your uncle or auntie. This clause is showing the conditional inspection subject to certified home inspector for the deficiencies and obtaining the report satisfactory to the buyer at his own expenses. The buyer can argue with you. There is a small crack in the basement or small crack in the floor. But at the same time, as a salesperson, you have to understand the inspection clause only valid whatever you cannot able to see your eyes. Whatever the professional person bringing the equipments and finding out. If you are seeing there's a crack in the tiles, from the very first day, after the inspection, you cannot ask, can you change the tiles? That's already obvious. Before they buy the property, they're already there. Inspection only under roof. They find anything under the roof, or else moistures in the basement. Different valid reason, guys. Second thing, understand the real estate agent. You understand the inspection condition is a condition. Nobody get the perfect house. There is a minor issues. Anyway, if you are crossing the condition again, put the condition and cross the condition out. That's the second condition. The third one, if required, the seller agreed to permit the appraiser from the buyer's financial institution access the property for 3 times. We always putting our office, we always putting 3 times right now, because in case the last minute they change the one bank to other bank, the market changes is there. In that case, they can say no appraiser can go inside the house. Those kind of things. In that case, safe aside, we are putting 3 times. That's not an inspection side. That's not inspection. That's appraiser can call the rather rights to go to the property and get the appraisal. After pandemic, most of the appraisal are right through appraisal and the online appraisal, right through appraisal. Very seldom cases they go inside the house and finding the appraisal. Anyway, that's a clause for the appraisal clause. That's a clause. It's not a condition. Okay. The third one, seller agreed to hand over the complete set of keys to the and remote control. That's a normal one. The buyer shall have right to visit the property. The buyer shall have the rights to visit the property 2 further time period of completion at mutually agreed upon time. Okay, again I read this condition. Many agents having this problem with this, the last minute problem with the seller and the sell listing agent. The buyer shall have the rights to revisit the property for the time prior to the closing at mutually agreed upon time. Mutually agreed upon time. The day of the closing, early morning, you're making an appointment and you are saying, I'm going to come and see your property while they are moving in the middle. Yes, please use your common sense. I get the calls from salespeople time to time. They said, I make the appointment to go and see the property. Today, they are not allowing us. Make the time in advance. If the property is a rented property, just you may want to see the day of the closing and verify that the tenants move out and you are getting the vacant property and this and that. Please understand you are a salesperson, the professional salesperson, and talk to the other seller and listing agent in the timely manner to arrange the moving side. If the seller moving a little bit delay, some people get really upset and everything. Please understand the basics. Okay. The second, another question: seller at his own expense agreed to supply of the buyer copy of the existing survey of the property within 7 banking days upon acceptance of the offer. We are saying existing survey. They cannot give you the new survey. New survey cost depends on the house location and depends on the property size. $1,500 to $5,000. But the existing survey is the one we are asking, and we are saying within 7 days. Keep the you have every salesperson must have the sheet. You have to mark to tick out when is the financing condition expiring, when is the inspection condition expiring, when is the title search date, when is the survey due. Make a schedule, make a chart. I was using that one when I was doing as a salesperson. I was using that one, and every file after once I finish a deal, I staple it and I mark it right away for the expiry date, for the condition expiring dates, and that's a good reminder for you guys. Make a log sheet, and do those ones. In that case, you don't miss anything. Okay, within 7 days, seller has to give it to the buyer, and if you are a listing agent, you have to give it to the buyer. Most of the smart listing agent does. The day of the firm offer, they always give the survey and not to get in trouble. And the other offer, other condition, other clause for the freehold offer, the seller agreed to discharge any mortgages, lien or other income. That's not a very important one. The last lawyer's job, they are discharged without giving them, but still we are putting for the courtesy. The seller agreed to warrant that the fixtures and the chattels are on and the completion date and will be on the working condition. Just we always put the fixtures and chattels are there. Whatever you are seeing, it is there, and supposed to be working condition. The reason, if it's a long closing, many agents complain if the closing is 3 months closing. After that one, seller doesn't keep the washing machine in the good shape, and they don't clean the property, and there are some issues. Then we are putting those kind of clauses. If you are listing side, tell the seller to keep the chattels in the same condition as the day of the buyer seat. And if you are a buying agent, explain the clients for the revisit time. Okay. The buyer is to the agreement acknowledge the real estate brokers or salesperson so named as the agreement recommended the parties obtain the independent professional legal advice prior to signing the documents. We are putting this clause, our office, the reason get out from the trouble. The legal side, because the clients might say, I don't know anything else, I don't even know how to read English, and I sign it. But we are putting the clause, get the legal advice, especially for the GST part. Especially for the GST part for the new home. After they bought the property, you are selling it. You don't care about the GST, but their part, but they can come back and say, you don't explain to them about the GST. These are the one we are covering, all these clauses for you guys. If you are altering something, very carefully alter, okay? The seller representative warrant that during the time of the sellers own the property, the use of property, building structures, they are in marijuana growth. This clause is become weak right now because the government is allowing to grow marijuana, for marijuana in one detached houses with the permission and everything. But still, we are putting this condition. But careful this one. Some agent get in trouble with the condos. The condos only we can talk about the particular unit, not the whole structure of the. For example, 80 Corporate Drive. If 80 Corporate Drive, if you are putting 80 Corporate Drive, the whole building, maybe the the unit owner, he live in the 1006. How come he's responsible for the whole building? Okay, then we can put this clause for the only for the particular unit. But still, if anything you need specific more details, just if you are in the situation, call me. The seller do not warrant the rectover status of the basement. Buyer acknowledge being informed that the basement is illegal and doesn't comply with the fire and hydro codes. We are putting this condition for the basement side because the reason you are buying the property, what kind of property you are buying? Single family resident. You want to live yourself, single family resident. But if you want to have a rental income, yes, you can do that one, but that's not a legal one. The city have all the rights, but they don't implement the rights. Again, I want to use the word. City have all the rights to come and shut down, but they don't implement the rights. The reason, if somebody live in the basement, it's good for you. You can collect the money and pay the mortgage. Then you don't leave the house, the bankrupt. And the housing problem. If the city doesn't want to go through the housing problem, if somebody live in the basement, they're happy. They're happy that decision you are renting out to someone. But at the same time, city regulation, just you cannot do it. In this case, if we have a basement, separate entrance, the basement, that means you can legally fight. My experience, most of the landlord or the owners was in trouble. If they fight with the tenant is an educated tenant. He informed the city saying that was an illegal apartment. He is renting out. What will happen? City comes in, they lock it out. Then you have to do certain things. But for the safer side, guys, we are putting in the offers the rent offer status in the basement apartment, and is an illegal one. But you can rent it out. You can let your in-laws to live there without the kitchen. If you want to put the kitchen, you have to legalize. There are some of the issues are there. That's a separate seminar then. This is basically for the freehold offer. And I'm going to go through the condominium. Not too many changes for the condos. But form number 101. Form number 101 for the condos. The form number 101 is giving the access. Giving the access for the form number 101, giving the access for the, and giving the space for the, putting the unit number, level, and the building number. What you are buying is a townhouse or condos. We have a legal description. We already studied. You guys know that when you studied the difference between the freehold and the condo, how you registering in the land registry. The condos, they have a plan number, lot number, and the registration is there. Condos, the registration, the land registry, building number, level number, lot number, and the property management codes and those kind of condominium plan number, and those are the ones. In this case, the phone number 101 giving those options to make the offer easier. But the legal side, phone number 100 and 101 not much different. The HST side and everything is the same. But there are the clause number 7. They are giving us the common expenses. They are giving us the common expenses. That common expenses. How much is the common expenses? What is including the common expenses? The other one, the condos, the change of regulation in as per my over the head is 2004. They changed the regulations. The new condos, the meters are separate meters for the new condos, but still there are some condos only the hot water maybe want to make it cheaper for the hot water, and they may have a boiler, hot water boiler, and that's maybe including the maintenance fees and everything else separate. The brand new condos in the downtown Toronto, we can see the hot water tanks are inside, hidden in the condos, and small tanks in the overhead, and plus the heating and air condition is just one HVAC system work parallelly for the heating and air condition. In that case, carefully put the common expenses, what is covered and what is not covered. Insurance, what is insurance and the water. Mostly the water go as a common. There's no water meters. I don't see it in the condo site. Very less. Some townhouses I see in the water meter, but mostly water is connected. Check it, whatever is there, and make sure to mark that one. That's number 7. And condo site, there's not that much difference other than the status certificate. The status certificate clause is there. The status certificate is a clause. The offer is conditional upon The offer is conditional upon seller providing a status certificate at his own expenses within 10 business days. The 10 business days from acceptance of the offer. That's a standard. Used to be 5. They changed it to 10, I believe it's 2012. The Ontario government advised to change for the condominium corporations to give more time frame. Okay, this clause is very important, guys. Please listen and understand the status certificate clause. Okay, the offer is conditional upon seller providing a status certificate at his expenses. His expenses. That can be anybody's expenses. You can change it out to the buyer's expense, seller's expense, or salesperson expense. But the standard form we putting seller providing his own expenses. The use of the subject property has not been expenses within 10 business days. 10 business days, not 10 days. Different than business days. 10 business days of acceptance of this offer upon the buyer's solicitor approval, says status certificate in 2 days, excluding Saturday and Sundays. That's also is a business day of acceptance. Otherwise, offer shall be become null and void, and deposit shall be returned to the buyer without interest. Okay, there are a few things we need to talk. Okay, this is a condition. Some agents, what they're doing it, they are getting the status certificate in advance, and they're keeping it in their hand. And after the offer, they're giving immediately delivering to the buyer. Go and check it. In that case, they are bypassing the 10 days holding period. Then the time clock start. The buyer agent or buyer or the selling agent give it to the buyer's lawyer. Time clock start from there only for 2 days then. But the same time, status certificate regulations. Status certificate regulation, after acceptance, the seller has to apply the status certificate under the buyer's name. Seller applying to the buyer's name. Status certificate is supposed to come under the buyer's name. And how they deliver the status certificate is a delivery method. It's a major issue with the delivery method. Now it's okay. 3-4 years ago, major delivery with the delivery method, because if they send the email, some lawyers, they don't have enough advanced computers. They can't open it up. Even sometimes the status certificate come in the USB. They deliver the USB. The lawyers doesn't want to put the USB in their computer, and the agents, what they do, they go to the Staples and give the USB and print out. They're paying another $100 to get the hard copies to go to the lawyers. Depends on the system, but the lawyers are using it. Careful on those sides. Then you can ask for the hard copies if you can. And the status certificate, original status certificate, after acceptance of the offer, they had to obtain the status certificate under the buyer's name and give it to, based on the purchase sale agreement. Give it to the buyer's agent. And if they already apply the status certificate and keep it in their hand because the multiple offer situation, or they want to go faster, depends on the lawyer who approving. You don't need to reject. You can take it and you can tell your lawyer to get the updated summary copy from the property management to verify. We are real estate salespeople. Our motivation is sell the property. I'm not a lawyer. I'm not saying anything not to do, not to go too picky and not to make any transaction. But if they already have a status certificate, don't fight and get the status certificate and review it and look at the date of the status certificate. At least if it is recent. If they get a status certificate 3 months ago, we don't know what is the issues the property have after that one. And okay, plus let your buyer and go to the lawyer and review the status certificate with the lawyer. The reason, any pet, your buyer have any pet, the status certificate going to show what kind of pet they allow. If there are any other swimming pool is in the building, what time the swimming pool open and close. The swimming pool close at 9 o'clock. The client come to work from 11 o'clock and saying, I'm buying the condo, I want to go to the swimming pool in the night time. They can't. They had to check it out before they buy it. And the locker, parking, and plus more than that one, the basic one, the moving arrangement. Many poor clients, they buy and they don't know. They had to get the permission to move from the security guard. And what are the time they can move? Sundays they cannot move before 10 o'clock. There's a limitation. And plus the status certificate going to show what are the interior decoration you can do. If you want to break any walls or make a regular washroom to stand shower, everything you have to get the permission from the property management and do it. These are clearly listed in the certificate, plus how much money they have. Money they have is not a big issue because it depends on the condo side. And then is there any lawsuit? Any city give, if it is an old building, what are the city gave the work order for that particular building for the parking or balcony or anything work order. Lots of things there, guys. In that case, status certificate is important one. If you are a listing agent, don't think you want to get the listing, cross it out the status certificate and sell the property and get the money faster, but that's put you in trouble. And the same thing, buyer agent, very careful. If you are going for the multiple offer condition and you think you don't want the status certificate, at least make the status certificate as a clause instead of the condition. Okay, that's mean the status certificate, the offer is conditional upon seller providing status certificate. You can cross out the condition and get the status certificate and let the buyer understand, and he had to buy as it is anyway. That's the most of the one for the that's the difference between the freehold and the condo. But the key arrangement for the condo is tricky. Because of the front door door pop and everything. Sometimes some sellers return it and get $30 back and go. Some cheap sellers, and make sure to put it in writing how many keys and how many remote controls they have, and they had to leave it to the lawyers. That's very important for the condo side. Nothing else for the condo, guys. And when you are dealing with the condo, please you physically visit and see the parking. Where is the parking? Where is the parking located? Someday the parking is near to the front door. Very hard for the client to park and take it out. There's a 5-level parking. The parking is in the all 5th level, the P5, very down. A single lady leave the condo. She maybe gets scared to park the car on the very bottom side. Check it, those kind of things before when you are showing the property and when you are making the offer as a professional agent. Okay, this is for the condos, nothing much. A locker and the parking, you have to see whether it's own or exclusive usage. If it is exclusive usage, the only you can use it. If it is own, you can even sell it to somebody else for the parking or the locker side. And I'm going to move into the commercial, cottages. Cottages is important. Then cottages is we are getting the too many deals for the cottage right now. Then what are the things you're going to see the closest for the other than the freehold and condos? Other than the freehold and condos, there is under the cottages. Okay, what you had to do, you had to look for the building inspection and the financing. Most of the time, some people want to go a little bit longer financing and longer inspection condition. The reason being, when you see the cottages, septic tank is there, and water well, septic tanks, and even drill well sometime. You may need to do some time to do the different inspection to verify the cottage side. If the waterfront cottages, just you can see the shore road allowance, whether it's owned or municipality owned, whether the clan's owned. There you have to look at those one for the waterfront cottages. And if you are buying the waterfront cottages, that's the other thing. You have to look at the wind direction. You have to look at the wind direction. Maybe you can see, oh, the water is facing. What kind of water you are getting? The wind direction pushing you the house, all the dirts from the lake, or else you are pushing away from your house. That's very important. Time to time, season to season, you can see that one. Okay, we're basically saying when it's come to the financing condition for the cottages, it's not like a houses. The cottage financing is a little bit much harder and takes more time than the houses. The reason being, one of the reason, septic tanks or holding tanks. If all the properties are coming with the septic tank and the holding tank. The septic tank is reasonably, all the banks allow for the septic tanks because mostly septic tanks are safe and reasonable. And the holding tank means There are some properties that come with the holding tanks. And recently one of the property, after they bought it, our clients bought the property for 2 years ago. Now they tried to sell the property. After they bought the property, they didn't use it much. Then now the next door neighbor said that the septic system is coming to their land, because it used to be the mother and the daughter, they keeping both cottages. Then when they do the septic system, they didn't care. They said it's okay, the septic bed is going to their neighboring house, doesn't matter, doesn't bother them. They put the grass on top of that one, no one knows. When the clients bought the property, they didn't know the septic bed is there. Now the other next door neighbor is telling them they want to immediately they're not allowing to use a septic bed in their own land. In that case, what's going to happen now? They're going to keep the holding tank. Holding tank, what is holding tank means? All the dirts, kitchen dirts or washroom dirts or whatever they are, going to hold in the tank. The time to time, the peoples come and clear it out. That can be based on the usage, maybe every 2 weeks or every month. Very fast, that the smell is going to be there too. Holding tank is if the property comes with a holding tank, as for my knowledge, as I'm telling again, as for my knowledge, the major banks doesn't want to give the mortgages for the holding tank properties. In that case, the clauses are very, very important, and the inspection is very important. Septic tank, you have to, if you want to do the septic inspection, I did before some certain seminars how the septic tank looked like and everything. Even I recently seen one of the house septic tank. They open the water for 30 minutes, and the end of the bed they take the water out and testing it out and seeing that one how clean the water is. That much testing, some people are doing it. Anyway, you have to do at least the septic system is a working condition. Then that's supposed to know. But if you are dealing with that one, put the clause and try to find the inspector who can do the septic inspector, and take the inspector and do the septic system. And the financing side, yes, very hard to get the financing with the 20%. You may need 30% or more financing side for the properties. Second thing, I would say based on my own experience, guys, this one, the property near to the waterfront, insurance. The regular houses now, insurance, you pay $100 a month, in $1,200 per year. That we feel like even is high. We are looking for the insurance $50, $60, but it's going over $100. But if we are buying the property in front of the waterfront property, insurance can go. If you want to get the coverage for the water coverage, insurance can go $1,000 to $1,500 per month. If you want to have the full coverage, because your house is located in front of the water. Anytime the water flood can come inside the house. In that case, you can want to put the condition of insurance. That's fine. You can do it and check it out. Otherwise, the insurance, you can't get the full insurance. The house is in front of the water. When you are buying the cottage, the water system can be many different ways. The water system. And you had to have the inspector to check it out, the pump system. Where is the pump located? Pump located inside the house or pump located inside the water well? It can be both sides. If it is a water well, not close to the house, they may need to have two motors. One motor from one motor inside the well, another motor closer to the house. There are so many ways: duct well, tube well, so many different kind of wells are there. You may need to do the inspection. The clauses are here. I'm not going to read through. I'm only giving you the explanation. But always we put the cottage properties. I inform the office to put the clause, the common clause saying that one. The agreement of the condition, buyer being satisfied with the due diligence, his or her sole discretion, 10 days time. The reason we put this, the due diligence, under the word due diligence, covering everything. That's for the zoning side. For the zoning means for example, shore road allowance, 66 feet land. Who own it? That's coming under the due diligence. every other clauses coming under due diligence, you are safe. Leave it to the seller, but at the same time, sorry, leave it to the buyer. But at the same time, I know some agents, even I seen, I'm not complaining anybody, but it's a concern only about the condo. I saw the list, I saw the condo offer last month. They close all the conditions. They close all the condition and both the cottage because of the multiple offer. That's a high risk situation, guys. Careful on those one. But you have to find the different inspectors if you want to buy something, if you want to do your job right. And plus, if you are doing the cottage property, come with the water well. You have to check the water to the city. You have to check the water to the city, and they give you the bottles, and they have to use their own bottles, not your bottle. They have to use your own bottle and give them and test out the water. And even the inspection time, even the cottages, there is a filtering system, 2-kind filtering system, 3-kind filtering system, drinking water filtering system. There are so much different there. Get some basic idea and leave the buyer, tell the buyer to get the right inspectors to check it out. That's what I could say for the water and everything. But anyway, they had to have idea to buy too. If somebody buy the cottage, they should have some basic knowledge to buy. I'm not expecting our agents should know everything to everything, but still we had to, agents supposed to have some idea. If you want to work with the cottages, bring your questions and ask me the question. I can tell you whatever I know. Otherwise, I can pass it to the special guys. I can bring in some engineers to talk to you guys. And we're going to go through the commercial side. The major difference between the commercial offers and the residential offers. Commercial can be under the regular retail. Commercial, only one form we are using it. Form number 500. That can be a regular industrial, retail, office building, can be many different categories, but we are negotiating the price. Under the commercial, mostly either lease or buy. The major difference between the residential and the commercial, both are contract we are signing. At the same time, if it is a commercial, if the commercial lease comes, that contract, the residential lease, for example, residential lease versus commercial lease. Commercial lease is a 100% clear contract law. We are going to the courts, it's going to be contract law. In the residential, the landlord-tenant act is there to cover the tenants and cover the landlord in one side. Under the commercial side, there are a few clauses. I want to talk about the commercial, not the lease today. To talk about the commercial, another 10-15 minutes about the clauses for the commercial side. Commercial side clauses, the standard clauses, guys. Please again get the printout and read clause number 1, clause number 2, and what are the clauses, what are the standard forms, there. And when you go to the standard form, HST number 7. HST is very important. HST side. That's the difference between the form 100 and form 500. HST, I'm going to read the clause number, standard clause number 7. HST, if the sale of the property, real property as described above, is subject to HST, harmonized sales tax, then such tax shall be addition to the purchase price. HST in addition to purchase price. For example, you are dealing with the commercial property, $1 million commercial you are dealing with. If you are dealing with a $1 million commercial, who pay the HST? Buyer is the one pay the HST. If you don't put this clause in addition to HST, that 1 million including the HST, that means who is going to pay? The seller going to pay the HST in case you don't put that clause. But the form number 500 clearly showing, careful, in that case they cross it out or they change it anything, very careful. Before we go to the clauses, I'll tell you one scenario, what happened to the office last year. The real estate salesperson, he listed his own property. It's a store and apartment. Maybe the agent is listening today. Own property he listed, and he never asked anybody. He never discussed with the lawyers. Never asked question to anybody. And he listed the property under the freehold. He listed, and they get the offer under the freehold. And I believe he doubled in the transaction. Anyway, he received other companies in the offer under the freehold. Freehold means phone number 100. What is the freehold phone number 100? HST excluded. Okay. Phone number 100. Phone number 100 clearly showing. I read it again for you guys. Phone number 100. Phone number 100. HST close. Number 7. HST for the freehold property. The HST is including the price. We put the including the price because we don't need to pay in addition, because the residential resale, there is no HST. That's mean the form number 100 we putting including in. Here they clearly mark where the space we put including in, no excluded. Okay. Here is already standard form. Write it down, HST in addition. That particular salesperson, he listed his own property, he listed, and finally he doesn't care about HST, the time of the closing the transaction. I believe the property value around 600,000. They put half 300,000 for the commercial and 300,000 for the residential. The $300,000 worth of HST, $300 worth of sales price, HST 36,000 went to his seller's shoulder. Buyer said, I'm not going to pay. Based on the contract, I don't need to pay. In that case, who's end up pay? Seller end up pay. I think finally they negotiated to pay some different amount, but still seller lost money. Careful. We are dealing with the transaction. If you don't know, read and understand, ask the lawyers, ask the office. Okay, here the commercial HST in addition HST. But I'm not scaring you. We are salespeople. We want to make the sale. Even commercial guys. I know somebody recording this one. But still I'm telling you, even HST, there are ways you can skip the HST, talk to the accountants. There are ways you can waive the HST. Even though you're buying $3 million property, there are ways, go to the accountant and consult with the professional accountants. The way you don't need to pay the HST. I talk about $300,000 HST, okay? But there's a major exception. If the residential property, they're doing as an Airbnb. The residential property, they are doing Airbnb. What happened? The time of the transaction, HST part, you cannot waive the HST. Commercial, just the accountants fill out the waiver with the CRA, and there are so many ways we can defer the tax or postpone it or else waive the HST. But the residential using as a commercial purpose and HST, they had to pay the time of the transaction. There are issues there. All right, careful on those ones. And under the commercial side, there are commercial clauses. Under the commercial clauses, I'm going to go through the commercial clauses. Another 10 minutes time we have. The first, as usual, buyer agreed to pay for the balance of purchase price. That's there. Second thing, the offer is conditional upon arranging the satisfactory financing 10 days. We usually put 10 days. Sometimes if the environmental, if it is a freehold commercial compared to the condo commercial. Condo commercial, there is no environmental report. If the freehold commercial, environmental report come in, sometime 30 days, 60 days, you may need it. It depends on the type of the property, okay? Financing condition is there. And the second thing, the offer is conditional upon inspection of the subject property. What kind of inspection you're going to do? Either structural inspection, engineering inspection. If it is a gas station, you need to verify for the drainage lines. If it is a paint booth, nowadays marijuana places, we had to see the air quality machines. There are so many inspection sites we had to see. HVAC system, where is the HVAC system located? Is in the side or is in the rooftop? What kind of HVAC they are using it? What is the connections are? There are so many things we had to see for the commercial side. And the next clause we always put for the zoning. The buyer shall have with 10 business days to accept of this offer. Satisfactory itself for the property is zoned in final binding under the relevant zoning bylaws. Zoning bylaws is two kind. If it is a condo commercial, you have to get the zoning bylaw by the city as well as the condominium property management. And if it is a freehold property, zoning bylaw only based on the city. The next condition is agreement is conditional upon buyers being satisfactory for the due diligence. Due diligence covering everything, saving your life. The next one, the offer is conditional upon approval of the terms here by the buyer's solicitor. Buyer solicitor review is very important for the commercial transaction, because anything goes wrong with the commercial is a high value product you buy. Lawyers supposed to read and explain to you. This must be included in the condition. You can't cross it out. You can't cross it out for the this kind of conditions is very dangerous. And the next one is the offer is conditional upon seller being able to provide the following document within 7 days. Number one, copy of the fixtures and chattels is anything is including. If it's a vacant land, we don't need to do that one. Copy of the statement of income and expenses. If it is a commercial building, it's already rented out. They ask for the income and expense for the commercial plaza. Yes, you need that one. All building permits and parking arrangement related to the building. Yes, the building is located in the what kind of park. There are 6 units. How they allocated the units for the all 6 people. If it is the common parking or the different parking, those kind of things. Copy of the lease promises. If the property already leased out, you have to get a copy of the lease, and you have to see how much lease deposit the owner have. The time of the closing the transaction, the lease deposit had been transferred to the one owner to other owner. The name of all the tenants and rental application, copy of the monthly rental statement, monthly rental law. Based on the monthly rent roll, we are looking for the cap rate calculation. We need to have that one. That seller has to provide within 7 business days. Confirm the last month deposit received from the tenants, and they have adjusted in the statement of the adjustment. That's the one I said. Any deposit is there. We had to find out how much deposit they have, and we had to receive the deposit. And the next one is environmental side. Offer is conditional upon buyer, not seller. The offer is conditional upon buyer determining the buyer's own expenses. All the environmental law and the regulations has been complied with. No environmentally harassment condition. For example, environmental, either who is the one doing it, buyer or seller, depends. Sometimes the seller might do the environment and they can keep the report. They may say, I already have the environment. But the buyer, you are applying for the mortgage from BDC or Royal Bank, they have a list of people who can do the environmental. In that case, even though seller have the environmental report, that environmental report is not for the bona fide company, and your bank not going to accept that one. In that case, environmental report whose shoulders is your buyer's shoulder. Are you ready to do the environmental? In case environmental fail, who's the one going to pay for the money for the environmental? Then we had to have some negotiation with the seller. If buyer doing the environmental, the environmental fails, if they are not buying it, who's responsible for the environmental report cost? We had to look at those one, and we had to have the negotiation through the lawyers and those kind of things before we firm up the transaction. Environmental side. The seller agreed to remove all the garbages from the building. That depends on the building. The seller agreed. The seller and the buyer understand, agreed to all permanent fixtures. That's a very basic clause. The major part for the commercial side, zoning bylaws as well as zoning bylaw, as well as income statement, how much money they receive, and the lease agreement, deposit clause, deposits, and the environmental and the financing. Those are the major ones. Those are the major ones, guys. Different properties, we may put the different clauses. For example, if it's a farmland, we need to put certain farmland conditions, and industrial land, the usage of the industrial properties, and those kind of things we had to put it in. And this is basically, now we have 7-8 minutes up to 11 o'clock. If anybody have a question, please come out and ask me. Otherwise, I'm going to check it out. What other questions we have? Okay, there's a question. Somebody sent it to me. Vaira, the seller doesn't have the survey. They do not need to give the survey to the buyers. Am I right, Anna? But the seller doesn't have the survey. Seller doesn't have the survey doesn't mean they don't need to give it. No, that's wrong answer. The question you're asking me. The question is seller doesn't have the survey. They do not need to give the survey to the buyer. No, they had to disclose in advance. They had to tell the buyer in advance there is no survey. In the offer, we had to say there is no survey. I'm not going to give the survey. If you want a survey, after you buy the property, call the surveyor and do their own survey. If we accept the survey clause, you have to provide the survey. But the survey is, if you ask me as a buyer side, survey is important. My answer is just a no. There are properties survey is important. There are properties you don't need a survey. For example, the property built after 80s. After 80s property built, that's already 30 years anyway. The property built after 80s, 30, 40 years, after 80s, but the city municipality have the sketch. Municipality have the plan. Municipality have the plan, and you can go to the municipality and get it from the municipality for the $25 and you can get it. But at the same time, the property in the middle properties, what are you going to do with the survey? The property, both sides, you are living in the house number 25, 23 and 27 is beside each other. They already have a fence. Your survey nothing to do with the survey. But at the same time, there's a drainage in the back. Yes, you may need a survey to see the drainage lines, where is the drainage lines going. And if the property is a corner property, if the corner properties are the problem with the fencing side, you may think, oh, I have a bigger land with the both sides, bigger land. You look like you have a huge land for the corner property. You can laugh and you can put some nice plants. At the same time, that you don't own the land. But if you want to put the fence, you should know the boundary lines to put the fence. And the fence regulation is there. How much fence you can put, whether you're putting the wood fence or the iron fence. If you put the iron fence, what kind of trees you can put it in? You cannot block the view for the drivers. Then in that case, survey is important to see the fence line. And you are buying the 30 acres land. Of course, you need a survey to verify the land size, or else you need to do a resurvey. There are so many things there. And this question, yes, if you don't, seller doesn't have a survey, disclose in advance. There is no survey in the offer. Disclose it in the listing. There is no survey. In that case, you don't need to give the survey. I'm taking the question. If anybody sends the question personally, we can discuss. Other than that, that's it for today. If you have any question, come out and ask me. That's all today.
Hello, Selvana. Sorry, quick question.
Okay, go ahead.
Yeah, this is Prabha. And you told from the residential property, we can get the survey from the municipality?
Oh, yeah. Residential property, the first access you can go, our GeoWare house, the survey company, they upload the survey. You can pay the money, and different survey companies have different charges, and you can do it online. Then that's easy way to do it. If not, go ahead. There's a website called protectyourboundary.com. Protectyourboundary.com is one of the good website. So many survey companies are uploaded their system. In that case, you can pull it there and pay the money. Other than your warehouse. If not, you go to the municipalities. Municipality not going to the full survey of your house, but they're going to give a sketch. That's enough. That's basic. At least that's enough to see the drainage lines and certain things enough. Yes, Prabha, you can check with the municipalities. Yes, but it's an old house, 100 years old bungalows. They may not go to have it.
Okay, thank you. So, is any particular survey good enough for the residential, or just is any different varieties of the surveys we have?
Detailed survey, you're not going to have a detailed survey. Come with the original builder. They give the detailed survey, marking all the lines. Other than that one, the municipality side, you can get only the sketch. But if you don't have a survey, the other thing you can do, ask the next door neighbor. Next door neighbor survey, most probably 99% cover your house too. When you go to the survey plans. Prabha, the survey, you can get the different kind of survey for the commercial side. There's a survey is a big difference. they're expensive too. But the residential houses, basically, there are two kinds only.
Thank you, Selvan. I appreciate that.
Okay, that's it for today. See you guys next time, next Saturday morning. Any questions, send it to me, text me. Have a great weekend and happy Father's Day. Bye.